Sexual harassment is something that I have been asked to talk about this year several times because it's on everyone's mind. The Me Too movement is something that isn't necessarily related to the workplace, but what it's done is made every employee aware that harassment is an issue. Harassment is something that they should go to their supervisor about, and even more likely to go see a lawyer about. So what we're seeing is a trend where, similar to California, where all the employees are educated about their rights in the workplace, now employees are educated about harassment and the culture, the male culture, and that it's not right and it's unlawful. And so what we're seeing is a rise in claims, but what, from your perspective as entrepreneurs and business owners, is important is there is an obligation, undoubtedly an obligation, to train your employees and to train yourselves on these issues to avoid liability. And so what I wanted to start with is not going through the gobbledygook of the law and the statutes and what the letter of the law is, but more give you an idea that sexual harassment is not just what you see in the news. It's not just rape or inappropriate touching. It's not just the business owner taking advantage of employees or prospective employees. It's a huge scope of possibilities under law that can lead to an harassment claim. And so on that end, one thing that needs to be clear is that both a female and a male can be the victim of harassment in the workplace. And people of any gender identity can be a victim in the workplace. So Tinder, the dating app, has 37 different gender identities. I couldn't name more than 2 of them, but they're there. And so that's an issue in our world that we see all the time, that there are gender issues out there that we're not aware of, and it's your obligation not to know 37 genders, but to know that there are people dealing with those issues, and that it's your job, if that comes to you, not to just throw it out the window and say that's nonsense. And this is going to just increase and increase. After this, you can ask me how many kids in my 5-year-old's kindergarten class are girls with different parts, according to my daughter. So this is something that we're going to be dealing with forever. There can be same-sex harassment. So that's male on male, female on female. That's can lead to harassment under the law. It can come from a supervisor. It can come from a coworker. It also can come from a customer, a vendor. People are surprised to hear that if a customer is coming in or a contractor is coming in and harassing my employee, that me as an employer have to go and deal with the customer. The customer is not right in that situation, and it's your obligation to go and deal with it. And like I mentioned, it's not just touching. There can be verbal harassment, like jokes and comments. Non-verbal harassment, which is a tough one to get your head around, but I just had a case in Fort Myers, Florida, where the woman, her only complaint of harassment was that her supervisor was sitting across the conference table and winking at her and leering at her. And he would do this in meetings with her peers with her. And she complained about it. It was disregarded. That's not harassment. She ended up filing a lawsuit, and what happened there was, because there was no investigation done, I was doing the investigation, and I found that this winking and leering and licking his lips at her was gross, but it was also impacting her, and from a reasonable person standpoint, she couldn't do her job. She was from a different country, and she thought that everyone at the table was seeing what she saw. And that, coupled with the lack of investigation, led to a settlement for her, led to a payday for her, because the company did not meet its obligations. Another form of harassment that's not touching is e-harassment. So the classic email forward, but also pornography in the workplace, the old male culture. So I had a case with a car dealership in Fairfax, Virginia, and you could picture the salesmen around the edge of the room with their computers, an old boys club from the 90s, and then they hire a female, and the female can see everyone's screens, and they can see the Playboy centerfold on Joe's screen, and they can see the pornography playing for the two coworkers to talk about, and she feels uncomfortable from that. And that's something that the employer didn't stop because it was just the way things were done, and that can lead to a harassment claim. And then simply treating someone different because of their gender or gender identity can lead to a harassment claim. Now, as business owners, as people in the community with reputations, we're not here to teach you not to harass. I think that's on your own plate. It's not something we can learn in 30 minutes, and it's not something you need probably. But what you do want to learn is how to avoid exposure from these kind of things. How do you avoid liability? Because most of my settlements, most of the cases that make it to a lawsuit or to trial, the reason they're getting that far is because you didn't meet your obligations to prevent it. You didn't put in the defenses that you're supposed to do to prevent these kinds of things. It's not the harassment itself. The harassment itself, if there's harassment there, yeah, that's not good. But if you've met your obligations and you've been notified of it and you've taken action, you're going to negate any exposure there. So that's the most important takeaway. And Tawny's going to talk a little bit about the policies and investigations and training that's necessary in that area to prevent this exposure and keep you from being on the hook. Because what we're seeing is in the small business arena that these lawsuits and the verdicts from these lawsuits can just implode your businesses. We're seeing shareholder lawsuits, we're seeing bankruptcies forced directly from sexual harassment lawsuits. And so what I would like you to take away today is that it's the failure to act on knowledge that is going to get you into trouble. So not to just disregard someone's complaint just because you have a history between employee A and employee B, and you don't believe employee A and you've known employee B for 15 years and he would never do that. That's not sufficient. You have to dig into it. You have to put your preconceived notions behind you and check the boxes. Otherwise, you will have no defense. And if this employee decides to pursue action, you are going to be on your heels and you're not going to have what you need to defend it, and the exposure is unlimited. And so before I turn it over to Tanya, I was looking for cases that prove this point. I've already given you a couple, but I found this case in Illinois where they had a $95 million verdict for a sexual harassment claim. And that was 90% of the small businesses' funds. They had that was it. This was their business. And that, eventually that's a large verdict and there's ways to fight that, but they're walking out of the courtroom thinking they owe $95 million to this woman. And this woman was an employee at a furniture chain, and she complained of her supervisor harassing her by pinching her, making lewd comments, giving her gifts. She complained about that. After that complaint, her supervisor hit her in the head with his genitals and then masturbated on her in the storeroom.
Oh my God.
Yes. So she complained about this. And
Wow.
she complained about this. And she was never contacted by someone to investigate her complaint.
Oh my God.
After that, her supervisor confronted her, and then her supervisor's supervisor confronted both of them and told her supervisor, who had pinned her in the storeroom, to watch his back because she was complaining about it.
Oh my God.
The company never took any disciplinary action against the supervisor. So, the jury awarded $15 million in compensatory damages and $80 million in punitive damages, which kind of sounds about right. And that was 80% of the company's 2010 profits. So that's the story of if you don't investigate, if you don't take these complaints seriously, no matter what they're saying, if they would have just talked to the employee, they would have found out there was a problem. And they didn't do the first basic step when you receive a complaint. So that I think sets the tone for Tawny to talk about what needs to be done to protect yourself.
Good morning. Thank you for having me here today. So Tawny Lima with Next Level Strategies. So I think one of the things too, so that's an extreme case, right? It doesn't need to be this extreme in order for you to really get involved. If anything is mentioned, there was a cartoon that people spread around that somebody was offended by. You still need to address it. It's very important. I think the thing that I would really like to impress upon you is a lot of the time, by the time it comes to somebody like Wilson or myself, that it's already set in motion. You've already kind of failed because there's already a situation happening where somebody's gotten to the point now that they're coming to outside counsel. So I think the more proactive you can be, the better it's going to be. Any business owner can take some of these steps to really show that they're trying to be a good employer and to set the proper tone and to really let everybody know what is and is not acceptable. So as far as some of the prevention, and one more thing to mention, the person that is complaining or making the harassment claim doesn't have to be the person that was actually involved in the harassment. It can be somebody that observed it. So maybe the two people that were involved in the actual harassment, they didn't make the complaint. It was somebody outside that witnessed it. You still need to address that situation. So as far as prevention, adopting a zero tolerance policy and just really taking that to heart. It'll help guide your decision. Zero tolerance, right? If you hear about a harassment situation and after you've done some investigating and you find that there was harassment, zero tolerance. You need to take action. Establish a very clear written policy against unlawful harassment. I'll kind of go through a little bit of the basics of that and what that should look like. And then communicate that policy to everybody on the team. It's not enough to just have the policy, right? Because then nobody knows what the policy is if it's just internal. You really want to get that out to the employees. Have a formalized complaint process. So once an employee feels that they have been harassed, what's the steps? Who do they need to go to? Who do they talk to? Again, it's not enough just to have a policy in place. Really let employees know how can they communicate that out to somebody if they're feeling harassed before they go outside and get an attorney. And then it's a bigger issue for you and your company. Thoroughly investigate and respond effectively and immediately. So as Wilson was saying, there are cases where nobody did anything. Somebody made a harassment complaint and then it just kind of got ignored or forgotten and never really went up the chain of command. So make sure that your supervisors know if a harassment complaint is made to them, they need to report it up to you as well. I have had several clients where the supervisor was aware of a complaint and nothing happened. They never reported that on to anybody else. The supervisor got busy with something else and it was never addressed. Well, that's a problem. Make sure that you know that the supervisor, it is their duty. They need to report that up to the chain of command, whoever that is, the DOO, the owner, whomever. It really, and they have a time limit that should be taking place, and I prefer 24 hours. It needs to be quick. If a supervisor hears about a complaint, 24 hours, they need to report it to the owner or the director of operations, the GM, whoever it is. Again, this should be in your formal complaint process so it's very clear. Document all the allegations and really, I can't stress this enough, don't write down your own interpretations of what you think has happened. Really make sure that you're keeping it to the facts of what the person is saying. In the end, Wilson, as you go to a court case, all of these documents are going to go with the case. So they might be presented to a judge and jury. So you want to make sure that you're not writing side notes of, I don't really believe this employee, I'm not really sure what's happening here. This doesn't seem factual to me. No, you were taking notes about what the harassment complaint is, all of the facts from that employee, and then dating it, and having the employee initial off on the pages as you were writing notes from their complaint. Another good thing is EPLI insurance. If you can, it is something great to consider that will help you kind of mitigate some of these situations. And something that I'm not sure a lot of people have heard of is a consensual relationship agreement form. If you have employees that are involved in a relationship and this comes to light, I would advise you to get them to sign a consensual relationship agreement form, which is acknowledging the fact that they're both entering into this of their own free will. Nobody's being coerced. They realize that they can, leave this, relationship at any point in time, and also agreeing to the fact that they're not going to be kind of affectionate on the work floor, making other people uncomfortable. And get them to sign and date that, and then keep it in the file. So that way, down the line, if somebody comes to you and is like, yeah, that person's been harassing me, it's like, well, we had this discussion. We went over that you were entering into this. You guys were in a good space. I understand things have gone sour now, but when you entered into this, you were both in a good space, and it was not, you didn't feel you were being harassed at this time. It's just a good way to kind of protect yourself a little bit. And people like Wilson or myself can help you with all of these pieces. Writing a harassment prevention policy. I would advise that when employees are hired, you give out this policy, you have them sign and date it, and you keep it with all of their paperwork. Again, this is proactive, preventative measures. You want everyone on the same page, that they are acknowledging that this is not going to be tolerated in the workplace. If they see it happening, even if they're not involved, they have an affirmative duty to let you know what's going on. Without the communication lines open, you might not ever hear about it. So the more that you get it out to the employees that there's going to be no retaliation, they can come forward and let you know what's going on, and you're going to look into it, the better it's going to be for you. I would also advise that you include the policy in your handbook. So not only do you have them sign off and date it when they are hired, you also include it in the handbook. That way they can always refer to it at any time. And everything's written out in that policy as far as the chain of command, that there is no retaliation, that they feel free that they can go ahead and communicate to you and there will be no retaliation against them. And I think one of the things that's come up quite a bit for some of my clients that have older policies in place is that communication line isn't broad enough. So it includes, we want a written formal complaint. What about if somebody's not comfortable writing down the complaint? What about if somebody is English as a second language and they're not sure how to actually write this out? Let it be verbal too. The broader you can make this, the more open the communication can be, the more you might actually learn about something before there is a larger situation at hand. One of the other things that has come up quite a bit is the reporting structure. So oftentimes an older policy might say, we need to have you report this to your direct supervisor. Well, what happens if the person that's been harassing them is their direct supervisor? Now what? Now what do? They probably won't come to you internally. They're going to go and file a claim outside before you even have a chance to correct the situation. So I really advise that you list out in your policies any member of the management team or our outside counsel or our outside business partner or our HR consultant, whoever outside of the company as well, because again, you just want them communicating. You want a chance to rectify the situation before it becomes larger and it's a $95 million case. Let's see. In Texas, there is something that you could do that's pretty proactive and not required here and very simple because it's free. The Texas Association Against Sexual Assault actually has a free pamphlet confronting sexual harassment in the workplace, and you can just download that online. Make it part of your new hire process, your onboarding. Give it out to every employee. and it's free. Why not? One more measure to show that you're really trying to be a good employer, and you're trying to make sure that everyone is aware of where they can report to, what they can do in case they do feel harassed. And then the other thing that we haven't really touched on is the prevention training. So harassment prevention training is a really great proactive measure where you can bring either all of your employees together. You can choose to do your supervisors and your management staff. I prefer doing it to the entire team and just going over a lot of the pieces that we've touched on today. Basically, you know, what is the definition of unlawful harassment? What are some of the types of conduct, some of the more relatable aspects that you might be able to tell employees, so it really starts to click in as to what the harassment really is, so that they understand it in a level within their employment, that they're going to understand those examples. And then some of the great things that have come about from some of the trainings that we've given is it really gives the company almost a platform to open up a wider conversation of what do we do if we have a UPS driver that comes in every day and I see him harassing our receptionist and she's uncomfortable and I can see it happening every day. What do we do in that case? And it just becomes these kind of overarching policies that are happening with the employee's involvement in the moment of the training, which has been amazing, and things that we've actually built into either an ops manual or a handbook, where what do you do if a patron who's sitting at the bar becomes really intoxicated and starts harassing other customers? What is the protocol? How far can that go? But he's our top paying customer. You know, we all love him. He spends thousands of dollars here every month. Well, still, let's talk it through. Let's see what are the steps that we could do to help mitigate the situation.
Transfer the employee.
Yeah. And then training really should be interactive and engaging. You want to make sure that the employees are not just zoning out, that they really are engaged in the process. That's the whole point. You want them actually hearing the information. So really try and get them engaged in it. And again, this is showing how proactive you are as a company, as a business owner, that you really are trying to be a good employer and taking these proactive measures.
If I could just add to
yeah.
the training stuff. So I think a lot of people here may not have a lot of employees in their business, and they're wondering, how does this connect to me? So I think people may or may not know that a lot of the discrimination statutes apply to employers with over 15 or over 20 employees, but as a small business owner with less than 15 employees, you still have exposure. There's still claims that can be brought by employees who are alleging harassment. There can be assault and battery claims, there can be common law tort claims, there can be violations of public policy related to their termination. So even though you may not be covered by the discrimination statutes, you are still going to be covered and have some exposure under the common law. So it's not something you can just sweep under the rug because you're not big enough, or just avoid hiring that 15th employee. That's not going to let you get away with it or let you avoid this exposure. With the training, I sort of disagree with Tane. I think it is pretty much mandatory to train your supervisors on your policy. And why I say that is there are several states that require it under the statutes and regulations of the state, but the law itself requires you to provide training and disseminate your policy to the supervisors so that they're aware of the policy, so that you can enforce the defenses and reduce your liability for a claim. So if you're not training your supervisors, you've thrown that defense out the window, and it's not going to be available to you in a lawsuit. And regardless of the defense, that is always going to be a sticking point if your main witness, the supervisor, comes in and says, I never heard of that policy, or yeah, they showed it to me once, but I've never received any training, or yeah, sure, I know Bill Cosby did that stuff, but I don't know how that applies to my company. And I had a mock jury, which is like a fake trial in Michigan at the end of last year, because we were trying to figure out the allegations were sort of borderline. We didn't, is it harassment, is it not harassment? We thought we had a good defense. We did the right thing. The plaintiff wasn't being reasonable, so we took it to a mock jury to see how it played out. And we ended up, after the mock jury, deciding to settle the case. And the reason was, talking to the jurors, was the supervisor had never been trained. They couldn't get by that. They couldn't get by this one fact. This, to us, was a little fact. He wasn't even really a main player, but to them, it jumped out to them as we weren't really doing everything we were supposed to do. Your supervisor of the victim didn't even know how to use the policy, wasn't trained on it, was hired 12 years ago and hadn't seen it since. And that really just rubbed them the wrong way, so much so that they couldn't get themselves to come down on our side. So I think it is pretty much mandatory that if you have supervisors, if you have people out in the field that are in charge of employees, that once a year you sit down with them, you go through the policy, you say, "You understand this, Bob?" And he says, "Yes." It can be a simple thing, and then you have him sign a piece of paper. So 2 years down the road, or hopefully less than that, you can go back to him and say, "Yes, I got this," and you have a paper trail, and if you get into court or there's an investigator asking you questions, he can legitimately say, "Yes, this is important to my supervisor, to the owner of this company, because I sit down with him every year." Or my attorney comes in and has me sign this piece of paper that I understand this. Or I sat on Thursday morning at 7 a.m. and listened to some harassment training. Like, we take this seriously. And you just can't get away. You would not, I just can't imagine going in front of a jury or a judge and saying that we don't train on harassment after or during this Me Too movement. You just wouldn't look like you know what you're doing, and people just can't get by that. What else do I have on training? That's my spiel
So
on training
I would
people.
agree with that. I come from, before landing in beautiful Austin, Texas, I come from a land that is extremely litigious, where it is a state mandate for employers with 50 or more, but the training is incredibly intensive. It has to be 2.5 hours. There's all these stipulations. You have to do it every other year. So in the regard that Wilson's talking about, absolutely, like I'm saying, have that policy everywhere. If you can, put it up in the employee break room. The more you can disseminate that out, the better it's going to be for you. Again, showing that you really are trying to make everybody aware. Do you have anything else you wanted to add on training?
No, just on the complaint procedure, though, I did want to, as I spill coffee on myself, the one thing that I always recommend for investigating a complaint is have a neutral witness with you. Have someone who's not connected. When you talk about taking notes, it's wise to have that as your primary note taker. Someone who's just writing everything down, who can come in on the back end and say, "Yeah, I was sitting there, I didn't know the employee, no one's alleging I did anything wrong, I'm not leading the investigation, I was just sitting there watching." That's an excellent witness to have, and it's something to protect yourselves too. If you're a business owner and have to do this investigation on your own, it protects you, because then you have a witness there that's going to be able to testify or state that, yes, you didn't do anything wrong. You were just asking neutral questions, actually investigating this, and that'll protect you. So I want to make sure that that's something that's on your radar if you ever do have to do this. And then make sure you're interviewing everybody. There is a practice sometimes of like, let's get this done with. Let's just talk to the two people involved and make a decision. And you can make a decision based on credibility and different factors. You don't have to take one as true and one as not true. You assess the situation, you decide, is this something we have to deal with or not. But you can't really make that assessment without talking to the people that are in the same room with them 40 hours a week, or talking to the person that's coming in and out of the room, or walking through them, or works with one of them and not the other. So you need to talk to the the entire scope of the workplace that may have witnessed this. And sometimes it may not get you anything, but where it runs into a problem is if you haven't talked to them and then you go to court or you go get an EEOC charge and she has a witness that you've never talked to, that's a problem. You haven't done a thorough investigation. You haven't done what you're supposed to do in response. And you can't make a real assessment without talking to the witnesses. And then try your best not to judge people before you get in the room. The questions should be neutral, and you'll have a witness there to help you with that. But don't try to label the accused before you talk to him or her, and don't try to label the victim before you talk to him or her. Because you get to know people really well and you have a history, but you don't have a history of the two people and how they interact. And you need to take their word for what it is and investigate and then make the credibility assessment after that.
As far as the investigation goes, I like to really slow it down, have your questions kind of mapped out for you before you begin the interviews with each of the people involved. So like what someone was saying, you always ask kind of at the end of your questions, is there anybody else that you think that I should talk to? Is there anything that you feel that I should have asked that we didn't cover? And always kind of take a step back and almost like you are a second grader, ask follow-up questions. Don't assume anything. Well, he grabbed me. Well, what does that mean? How did he grab you? How hard? Where? Those kind of questions, the who, what, where, when, why, how. Always be drilling down, because honestly, the more questions you ask, the more you'll start to understand. Because somebody could say, he looked at me in a leering way. What does that mean? That's something very different to a lot of people. We all come with our own kind of impressions of what certain words mean. Really ask those questions to follow up and have a better understanding about it. And then, again, like Wilson had said, really make sure that you do have a note taker there, somebody who really is, you're engaging with the people involved and somebody else is taking the notes. And then have the employee involved in that interview sign off and initial those, read through. Was there something that we missed? Let them know at the end of your interview that you may be coming back to them for follow-up questions. Let them know if they think of anything else, please provide it. Wonderful things are text threads. People can take shots of those because so much happens over text now. So many clients have situations where there are after-hour communications between people and they feel like they're off the clock. So now they kind of have free reign. Well, no, you don't. You're still, that person's manager or coworker, and so all of those bits of information can really be helpful in making your full decision. And then I think coming back and once you've gone through your investigation, really kind of concluding that. I've had several clients where nobody ever followed up with the people involved. They made their decision but never actually got back to the person who made the initial harassment complaint. Well, that is unsettling. It feels as though you haven't done anything. Maybe you've done a ton. That person has no idea. So really actually communicate what has happened. I think something neither of us touched on is don't ever promise to keep confidentiality. You can keep it to the extent possible. You cannot promise that though, because once something's been brought to light, you now have an affirmative duty to really get to the bottom of the situation and what's going on, and to the best of your ability conduct a thorough investigation. That means that you might not be able to keep everything confidential. So I think people get into hot water there and they tell somebody in an interview like, well, don't worry, this is just going to be between us. You can't promise that. So really, keep that in mind. And then I think retaliation is something we haven't touched on, which is really is almost surpassing the harassment claims at this point, about retaliation claims. Double, if not triple, some years. So making sure that you really adhere to your own retaliation policy within your harassment policy, that there is no retaliation. People can feel free to come to you and voice their concerns and really share with you, and you're maybe not going to include them in staff meetings or give them a promotion or try and put them into another division where maybe they don't have the same a level of a role. These are all retaliation factors, and you need to be aware of it because it really is prevalent, and it happens quite a bit, and those are the majority of the cases at this point. Everybody thinks the whole quid pro quo, like you do this for me, I'll do this for you. That's a very small percentage of the cases being brought. It's a larger percentages, retaliation, hostile work environment, those type of cases.
But retaliation, simply put, as soon as someone complains, you need to walk on eggshells for the rest of their employment. You need to, every time after they've complained, every time that you want to do anything, you want to promote them, you talk to someone, you think it out, you write it down. Hey, you want to demote them, you talk about it, you write it down, you make a decision. You never do anything with that employee again off the cuff. You need to be really looking at them, and that sounds like retaliation in and itself, and it probably would be if there was an attorney-client privilege. But your attorney's going to tell you, now that this person has complained, everything you do, you need to call me, because it's such an easy claim. The reason there's so many of them is there may not be a valid harassment claim. It may not amount to harassment, but they've taken an action in opposition to protect their rights under the law, and now you've taken an action in retaliation within a certain amount of time period. It's just an easy claim to tag on, and it generally is easier to survive summary judgment, so to get to trial. So it's a strong claim in this situation, and the way to avoid that is being very careful with the alleged victim. So with that, I think we can end with a couple examples. A couple examples thinking through this that I think exemplify, like the earlier case. Tawny mentioned that it doesn't have to be the person engaging in the activity that can bring a harassment claim. It can be a third party that's witnessing this and is affected by it, is not able to perform their job duties because of the actions that are going on in the facility or the office. And so, back to Florida, which is my hotbed for harassment cases, pretty much any litigation, I guess. And I had a case in the Miami area probably 6 years ago. And the case began with an employee in a convenience store who was sleeping with a Miami-Dade County police officer. And we became aware of this because the police officer was ratted out by somebody that he was going to this convenience store and sleeping with a worker there while he was on shift and in his police car. And this made the news, some local paper there. And so we became aware of that. And almost immediately, the next day, there's an employee in the store complaining of this action, and that she was witnessing this and felt harassed by these actions. So we dig into it a little more, and we find that the employee was working a shift with the woman sleeping with the police officer. Follow me here. And the woman asked the coworker, "Please stop doing that at the store, it's bothering me." And the woman's response was to make it more apparent, to basically harass her with her relationship with the police officer. This meant bringing the police officer in the store and making sure that the complainer heard them, making comments as they walked out of the cooler after the acts that was great, we should do it again soon, I really, things like that. And so it just continued to escalate because they thought it was fun. And so the employee also told the manager, and the manager just didn't believe it. He didn't believe that a police officer would be coming in the store, going in the cooler, having relations with one of the workers while they're on shift. And so that was just disregarded. So it turned into not only a bad case because we didn't do anything in response, but then it turns into a public relations issue where you have a police officer who's on the hook for this problem, then you have a witness, and then you have a company who's disregarded it all. So this going on for 9 months or a year, we should have been aware of it. We should have been able to nip this and address the complaint. Instead, we let it escalate into a situation where they're having fun with it and basically advertising that it's happening in the store. We didn't get into the food safety issue, luckily. but it could have went there. So that, I think, brings us back to the scope of harassment is much larger than the supervisor and the worker and inappropriate touching. It can really touch any aspect of your business from any direction. And so I hope you leave here with that today. And then Jim had asked, what's really the worst case scenario? 95 million is pretty bad. And I found one from March of this year during this movement where it's a $2.6 million verdict. And I thought the facts here, again, showed how large a scope this is and the things that your failure to meet your obligations can lead to. So here, this was a male-on-male alleged harassment. And the main part of the harassment, where it started, was this guy's coworker kept spreading rumors that he was gay, which were false. So that's where it started. And we complained about that. The employee complained about that. Nothing is done. So the individual continued and said not only is he gay, he likes to get prostitutes at truck stops. And then he started pinching his nipples, touching his butt, and all sorts of inappropriate conduct related to this false rumor of him being gay. And it went on for years, and there's complaints about that. After years of that, nothing being done, there became physical contact where this coworker rubbed his genitals on the complainant's arm, and then he reported again. So in response to that, they finally did something. They suspended the wrongdoer, and they kept the employee, gave him his job, said we've done something, we've taken remedial action, just 4 years later, but we did it. And so, great. But what they did was that the victim was then reassigned his coworker's duties. So he had to take on more job duties to deal with the harassers being gone and being suspended. And this resulted in him spending additional hours on the road, which he hadn't had to do before. And this caused a lot of strain on his family. He had a new job because he complained, basically. So based on all that, complaining about that, they did nothing. They said, we've taken our action. We got rid of the bad guy. What do you want from us? And if you want anything else, go pound sand. This is it. This is all we got. But he said, well, I got something else. I'm going to go to court. And the jury sided with him and awarded $2.6 million to him. And so that's I think that's the story of it. Even if you're doing something, you got to do the right thing. Take away the skepticism. Take away the I'm running my business and this guy's just a problem. Go back. Get outside of that mindset and think, what is the right thing here? What can we do that's going to solve this problem? Because there are times where these complaints are real, and you have to deal with them the right way. And it's not right if you're creating a headache for the employee who's complaining. They've already gone through that. So unless Tanya has anything to add, I think it's probably time for questions.
Just the what do you want me to do about it is never the right answer. Never.
So my wife says too. I keep using it.
I do have a question. How many of these are frivolous? I mean, now with this in the spotlight and it's just these dollars, coming bouncing around in the millions. you know, how much is fake? How much is made up to try to get money? You know, how many of these cases?
Well,
are real?
I think that's the point, is that doesn't matter, because what matters is that you've taken action. So if you've received a complaint and find out that it's garbage, this is just someone out to take advantage of the Me Too movement, and you've investigated it fully, you've protected yourself. And that happens, that definitely happens, and it probably happens more and more now than it did in the past. But also what's happening more now is people are training and educating themselves on that so they can protect themselves in that situation. So your worst case scenario is that it is a frivolous claim and it didn't really happen, but when you found out, you didn't take action. And so then it lives on.
Yeah.
And then you've got exposure for the retaliation claim, and you've got exposure because you look bad, because your supervisors haven't been trained, because you didn't investigate, where you could have just gotten rid of the complaint right away.
I've had several situations where it is both employees involved, and it's not until one of them decides that they no longer want to engage in this kind of behavior any longer that they make a complaint. But then when you really start talking to them, and then the coworkers that have also seen it, it's both of them have kind of been involved. So that does come up quite a bit, but still, to Wilson's point, you need to do your due diligence and actually engage.
Kind of tied along with that, you were talking about I forgot what it was, kind of the practicing consensual.
Yeah.
That's what I was gonna ask.
Is there especially for a small business, it can be destructive to have, in-office romances. I mean, my personal policy has always been no fishing off the company pier. Can you codify that? Could I make a
That's-
corporate policy
Like, that's exactly what I wanted to ask.
and not end up in some nutso soup?
Right, it's honestly, it's one of those things that's a little bit difficult in that people are going to do it. I mean, how many people here have actually been in a relationship with a coworker? You spend so much time with your coworkers, that's where a lot of people meet their significant others. It is a hard thing to absolutely prevent. You can have a policy like that. Is it enforceable? That's probably more to Wilson's.
I mean, I think you could take action on that.
Because it's your policy.
Because you're taking action because of the relationship, not because of a protected characteristic. So if you wanted to say ahead of time, don't do this, and they put in a policy, you probably have a way to enforce that.
But a manager subordinate should never happen. You never want somebody in a position of power over somebody else, and if they bring it to light and you find out about it, somebody needs to be transferred or move on.
So what would legal action, what would protect, what would action look like? I mean, there's one, as an employer, I'd hate to say, well, I like you more than I like the other, and so, either break it off or you leave because you're not as valuable as this employee. I mean, how do you handle something
Maybe
like
give
that?
them the choice. It's been brought to light, you know that this is our policy, one of you needs to move on. It's not maybe your decision at that point if you don't want to be that person that's choosing,
Yeah.
or you can go who has seniority, who is the better performer, but just be consistent.
Yeah.
Yeah.
Texas, state of Texas has a reputation for being fairly lax in a lot of areas of compliance, especially this one when you compare it, say, to California or New York, which are the states that are probably the toughest. Can you describe the changes that are going on in Texas?
I think a lot of things come from these larger cities and kind of pushed here. Thank you paid sick leave now in Austin, right? We've been dealing with that in other cities for a very long time. Now it's come here. So I think that the natural progression is that you are going to see more things that are mandated here, just as things get brought more to light with the Me Too movement.
Well, I think the trends really are across the country is the PTO and protecting people on leave. That's really the issue that we see across the country. That's not really going to hit Texas. Even the Austin ordinance, there's already a lawsuit to get an injunction on that. That's not going to happen. So you don't have to worry about that. But
Famous last words.
it's not going
It's
to
not
happen.
gonna happen.
And pretty confident. And but what you're seeing in the national trends with the federal law that does affect Texas is things like gender identity and sexual orientation, where people either have had an argument that that's not covered. That argument is slowly going away. I don't think it's a valid argument anymore, that sexual orientation is not a protected class. So that's something that Texas employers probably have already dealt with, but now it's, I think, a reality. But yeah, this is a totally different landscape than the East Coast or California.
I just actually had a client call late last night who wanted to make an offer to an employee today that has a preferred pronoun, which is a new thing that's coming up where it's going to be one of those things that you're going to need to include in some of the onboarding process. What is the preferred pronoun? And theirs is they. So then all emails now need to, kind of follow that train.
So if there's a very small business, there's an employer with 3 to 4 employees, the chain of command for reporting concerns, would it be wise to have outside counsel as the point of contact?
Absolutely. Many of our clients use us, I'm just listed in the handbook. So the more people you can have that they feel comfortable reporting to, that are still affiliated in some way, but are still kind of have the company's best interest at heart, the better it is. So I would absolutely include that and just make it known into your policy.
If an employee comes to make a claim and then stops when they discover that it won't be completely confidential, can't be completely confidential, like what you were mentioning, and so they don't actually make the claim, what is the employer's responsibility at that point?
They made the claim. That they already brought it to your attention. The moment they open their mouth and brought it to your attention, there's a situation going on, and now you need to start looking into it.
So that needs to be brought out in the handbook, so they say if you complain, it can become, less than private conversation.
You can have that in your policy, but it's,
I mean, you're promising confidentiality, just not that it's just
overarching,
between you and I. So it's say just
to the
like
best of your
yeah,
abilities.
as much as possible,
Yeah.
and then you're sharing it only within the people that need to know.
I think Tim's got a question.
Yes.
So I'm a 30-plus year banker, and so when we have issues with borrowers that we've got to bring in and have one-on-ones and figure out a way to resolve, either getting more timely payments or whatever the issue is, we always have another person there as a witness. So what I'm not hearing in all this discussion is when these people come in, it sounds like it's one-on-one. It sounds like you need to have a second party there as your own witness so that you've got 2 people that heard this individual, so that it's not a he said, she said type situation.
Are you talking about in the middle of
Once
an interview?
Once the complaint comes in, it
Yeah.
it sounds like you need to have 2 employees in there
Right.
instead of just a one-on-one.
Right after the complaint.
Right.
I wouldn't
Yeah,
do that
so
just
you-
as a general business practice.
Right. Yeah, but you have that person in there that's going to be the one that's taking the notes, right? That is there. And then another thing, you don't ever want to bring the person who's making the allegation and the alleged harasser together in one meeting. Because it seems obvious, but it has happened. Yes.
Oh, right here.
Oh, sorry.
What about the current cheerleader controversy? I keep hearing about it.
In the NFL?
Yes.
Yes. My favorite Buffalo Bills are involved in that. Yes. Well, there's a lot of things going on there. It starts with they didn't pay them, which is interesting. And then they sent them out to golf events and made them be the beer girls and all that stuff. And their latest demand is they'll settle for $1 if they get to meet with the commissioner. That was the demand yesterday. But yeah, I mean that's a bad situation. And again, it's a similar structure. I mean, there's a collective bargaining agreement involved and a major hierarchy, but they had nowhere to go. So the policy aspect of it was not in effect. So they didn't have an open door policy where they could go to anyone. They had a policy where they were their little unit off the side of this major football team, and then you can picture a stadium. The cheerleaders are here, and they can't go up to the top and complain. They have no one to go to. So that escalated over years and years, and it grew into this thing. And then one team complains, they all complain, and now you have a situation where there are really no cheerleaders anymore because we have this lawsuit. So, I mean, that's, if you see that in the Post or Times or something, those articles are good lessons in what not to do.
I think Sam's got a question.
Yes.
Yeah, you said something that bothered me right at the start of this thing, was that there's now recognized 35 different sexual orientations.
37.
37
Are all
genders.
those protected under federal law?
Well, no, but your gender identity is. So 37 is an extreme example. But if someone is, there are issues to deal with if someone is transitioning or has transitioned or like we talked about has a preferred pronoun. Those, yeah, the non-binary world that we're living in now. So you can't just say there's male and female. So in places like the District of Columbia, I get emails from the agency investigators there, and on their signature block it says preferred pronoun is. And there is an argument out there, and in some jurisdictions it's established that if you're not using the preferred pronoun and you're doing it on purpose, that can lead to harassment. You're harassing this person who says, I'm not a he or she, I'm an X, and I want to be called X Smith all the time. And so you're calling me she because you know I used to be a woman, and you're doing that to harass me. So then you're harassing based on gender identity, which is illegal.
And that law only applied to the cases covered by federal law, it wouldn't apply to cases that are not covered by federal law.
Right. That would likely be a federal claim in Texas.
But it is one of those things, again, it's transitioning now, because it's come to light, it's been brought up, and there's more of a movement there as well.
Guys, we're at the end of our time, and so what I want to do is say you can stay around here for a little bit longer if you'd like, if you guys have a little extra time after the meeting and talk to some people, because there are some questions I have that I'm embarrassed to ask in front of the group. But anyway, with that said, thank you very much.
Thank you.